Συνεχίζουμε, κυρίες και κύριοι, με μια μεγάλη ερώτηση. Τι έγινε ύστερα από την ελληνική υπόθεση? Θα συνεχίσουμε στα αγγλικά. Ο κ. Μπένεντεκ είναι εδώ, το οποίο θα παρουσιάσω, ο οποίος ανήκει και στο International Advisory Group του Ιδρύματος Μαρανκοπούλου, που έχω την τιμή να είναι μέλος του Ελληνικού Συμβουλίου εδώ και πολλά χρόνια. And I want to welcome you, Professor in Graz, University of Graz, Austria, and also he has worked, still working, assisting the UN in issues regarding human rights, whether it's UNESCO or the Human Rights Council or UNICEF. And actually, I see even in Gambia.
That is all.
It's all right. It was only for me also. I was in Gambia once. The subject will be what happened after the Greek case that took place in Strasbourg, which was legally, I would say, unprecedented and politically quite important. What happened since then? Without more comments, I think comments will come later. I'll give you the floor and I welcome you.
So thank you very much. It's a great pleasure to be again at an event co-organized by Marangopoulos Foundation and also the Scandinavian Institutes, with which I have many working relations. So my topic, as you can see, is the effectiveness of the tools of the Council of Europe against democratic backsliding. What lessons can be learned from the Greek case for current challenges? The Greek case, as we all know by now, was particular in the history of the Council of Europe with regard to the protection of human rights and democracy. It was a test case where the bodies of the Council of Europe would be able to live up to the principles of the organizations. The keynote will address some of elements of this particularity and ask the question whether the spirit and political will to confront major human rights violations existing at that time can still be found in the Council of Europe today. Has there been a particular impact on the work of the Council of Europe at the time? And what are the lessons learned for today? What are the similarities and differences at stake? What was the role of the personalities acting on behalf of the Council of Europe? What is the impact of its enlarged membership today? Furthermore, the institutions and tools at the disposal of the Council of Europe as the democratic conscience of Europe against democratic backsliding then and today will be compared, asking the question, what are the factors influencing the effectiveness of their use? Which factors influence the so-called socialization of member states to become guardians of common European values? In this context, present-time challenges from anti-liberal forces and authoritarianism for democracy and human rights will be addressed using examples of the Russian Federation and of Turkey. Is the Council of Europe able to meet its accountability towards the peoples of Europe today? This will lead to some conclusions. What is the message of the Greek case for a proper response to the challenges of democratic backsliding and the shrinking space for human rights and the rule of law in the Council of Europe today, and some recommendations for the future? I will address this in a structure which you can see here, so you can follow a bit the progress of my presentation. I would like to start with the particularities of the Greek case and impact at the time, and focus first on the responsibility taken by member states. The main particularity of the Greek case can be seen in the fact that the tool of a state complaint has been used by some concerned governments, you all know them, which were not directly affected by the case for the sake of the common good, which means the preservation of trust in the European human rights system. The Consultative Assembly, which later became the Parliamentary Assembly, however, called in a resolution on member states to bring such case, so they had the first initiative. This kind of actio popularis was, however, taken against massive pressures and lobbying. We heard about it. And establishing the facts proved to be a heavy burden in the circumstances of time. So those states felt a moral duty due to many actors in the background, as we have now also heard in this very interesting symposium, which has become scarce in the world of pragmatism and neglect today. So let me focus a moment on the role of the European Commission on Human Rights, the Assembly, the Committee of Ministers at the time. The European Human Rights Commission was in charge of the case, submitted in September 1967. It decided on its admissibility. It established this subcommission to examine the merits. It needed courage to stand against the denials of the Greek government, in particular to interpret Article 15 on the state of emergency in a way that it did not prevent the Commission from investigating violations of several articles of the Convention, not only the non-derogable ones like Article 3. The subcommission insisted on investigations on the ground and on confronting the accused with the victims, as we have heard, which took place in March 1969 and after the hearings in Strasbourg in November 1968 before. This allowed important fact-finding on the ground, including historic confrontations of victims with their torturers. I will now not go into the details, but just say we all know the outcome. The government of Greece withdrew from the Council of Europe in what is called de facto suspension, so there was no expulsion, that needs to be emphasized. And while this contributed to the isolation, finally the fall of the junta, as it has just been said, the fall of the dictatorship still took several years, and Greece was finally readmitted in November 1974 to the Council of Europe. The Consultative Assembly did play a major role in addressing the challenge of the Greek coup by the colonists. It was quick to denounce the coup already in April 1967, by the way, thanks to an Austrian parliamentarian, Karl from the Social Democrats. And we heard about the role of Bruno Petermann, also an Austrian former vice-chancellor, who was then the president of the Socialist International. And so it expressed its solidarity with the Greek people. It appointed the special rapporteur, William Sigman, later on Max von der Stoel, which were able to visit Greece several times and do reports on the situations on the ground until, as we heard, Max von der Stoel was declared persona non grata by the Greek authorities. He was accompanied by a young civil servant at the time by the name of Peter Leubrecht, and I'm quite happy that on the previous panel his merits have already been referred to. In a recently circulated text under the title of Fighting a Dictatorship in the Homeland of Democracy, Peter Leubrecht shared some memories of this time. This was in a publication at the occasion of 70 years of the Council of Europe, which only came out last year. Among these memories, I found one anecdote when he says, when he reported that they were interviewing, among others, Ioannis Sigdis, who was a former minister and member of the Parliamentary Assembly. But Mr. Sigtis was so afraid to meet him and to talk to him openly that they decided to go for a swim. And during the swimming, they led the interview. And Peter Leibrecht observed that it was a bit difficult for him to take notes. So this was, I think, important to see also the people behind, as it has already been alluded to. These reports allowed the Consultative Assembly then to become a driving force behind the campaign of the Council against the military regime. The rapporteur, based on his visits and his information, was the one who made an important impact on the decision to potentially exclude the Greek government. Another personality which obviously needs to be mentioned and which has already been alluded to several times was Max van der Stoel, because he brought convincing evidence of the so-called administrative practice of torture. So on the basis of his reports, this was finally established. We all know that he later became foreign minister of his country and the first High Commissioner on minorities of OSCE, whereas Peter Leibrecht himself became the Director of Human Rights in the Council of Europe and even Deputy Secretary General. But as a man of principles, he left the Council in 1998 because he was not convinced that the admission of some new states, like the Russian Federation, which missed the necessary qualifications in his view, could be absorbed by the Council of Europe without damage to the organization. By the way, there is a nice book which came out last year, The Faces of Human Rights, with Hart Publishing, no, this year even, and here you will find portraits of both of these personalities. Now I talk about the impact on the Council of Europe. And I wanted to point out, because this has not mentioned much so far, that the Greece case appears, at least to me, to have had some impact a few years later when a military coup took place in Turkey and resulted in the dissolution of the parliament and the abrogation of the constitutional protection of human rights. Again, a few member states, Denmark, France, Netherlands, Norway and Sweden, resorted to the tool of the state complaint in 1982, claiming the violation of a whole list of human rights. The complaint was declared admissible in 1983, based on a report of the European Commission on Human Rights, and the Turkish government, which claimed Article 15, state of emergency, had difficulties with this claim because the applicants found that there was not a sufficient reason for this emergency. However, in this case, because of the political developments in Turkey, it ended with a friendly settlement in December 1985, after a delegation of the Commission had visited Turkey earlier that year. It should also be noted that the recent practice with regard to the Russian Federation after the Crimea event, not to recognize the credentials of their MPs, has a precedent already not recognizing the credential of the Greek and later on Turkish deputies in those cases at the time. Now I come to the role of Europe in the democratization of Europe. In the state complaint of Austria versus Italy, one of the first ones, the European Commission formulated the principle that the convention was not about reciprocal rights, we have heard this yesterday and also by President Sicilianos, and national interests, but to realize the aims and ideals of the Council of Europe as expressed in its statute, and to establish a common public order of the free democracies of Europe with the objective of safeguarding their common heritage of political traditions, ideals, freedom and the rule of law. So President Sicilianos talked about erga omnes obligations, and this is, I think, important that it's not about reciprocity. Now, when we look at the nature of present-day challenges, and I put you this because a few days ago we organized in Graz, at the occasion of the launching of our newest European Yearbook on Human Rights, a talk of Niels Muschnieks, the former European Commissioner on Human Rights, exactly on this topic of democratic backsliding in Europe and what can be done about it. He has published an article about his efforts in this yearbook. So present-day challenges are characterized by populist and authoritarian governments, neglect of European values, violations of key human rights, lack of respect for the division of powers, which all form part of this phenomenon of democratic backsliding. It's not just a European phenomenon, because as Freedom House in its report of this year found out there is a backsliding of democracy and freedom of expression worldwide since 13 years. It's not the good news. So that raises the issue, what is the socialization effect of the Council of Europe? What has it been in the past? Which factors influence the socialization of member states to become guardians of common European values? The theory of socialization is based on the assumption that members of a club would have an interest in living up to its principles and values and thus will earn them recognition and reputation. This has been a major outcome of Council of Europe membership for new democracies, which benefited from membership to transform their political system, including the Russian Federation. However, the attractiveness of membership seems to have lost appeal. Some member states seem to consider it, at least as much as their human rights obligations are concerned, rather as a burden. The same holds true for the principles of democracy and the rule of law, which for some governments stand in the way of their authoritarian ambitions. Against democratic backsliding, various forms of social pressures have been used by bodies of the Council of Europe, but without much success. These included dialogues and offers of assistance, like through the Venice Commission, but it met with little interest by the states which want to go a different way, as we can see from cases like Hungary, Poland, but also Turkey. I personally have been involved in missions of the European Union and the Council of Europe to Turkey on the issue of freedom of expression. We were training the Turkish judiciary on freedom of expression, but after the state of emergency, where many of them were sent to other places, lost their jobs, even ended up in prison, all these efforts seem a bit in vain. And also I was the last time in Turkey as a member of the Venice Commission, and we made a nice opinion what should be changed. In this case was the information law. It was not even disregarded from the Turkish government. They couldn't care less. So in such a situation, when you do not care, what is the effect of such tools? We have heard in the Greek case that the colonels did care to some extent, which was, I think, an important factor, which today, in these democratic backsliding trends with populist governments and authoritarianism as a trend, we seek to see less and less. The cases of Poland and Hungary I'm not dealing with here because they are taken care of more by the European Union, and this is good that way. But other cases would be worth giving a closer look. But before, just a few words on the tools of the Council of Europe to avoid democratic backsliding today. So, one major tool, obviously, is the role of the European Court of Human Rights as a major pillar against backsliding. But the court is confronted with increasing claims of sovereignty, subsidiarity, margin of appreciation, and so on. There were these various high-level conferences from Brighton to Copenhagen, which all tried to limit the role of the court. The court, for some, is too evolutionary in its jurisprudence, leaving behind those states which want to stick to their more conservative values. For example, Russian Federation, we hear that they have a problem in adopting a law against domestic violence because this is against family values. It's strange, isn't it? So the authority of the court has been put at stake in various ways, in particular also by the non or weak enforcement of its judgments. The court could, however, maybe be more forceful, more strongly in its approach, for example, using the pilot case procedure or giving priority to cases which affect democracy. It does not seem to do so for reasons which I hope somebody will enlighten me what is behind. Now, then we turn to the Parliamentary Assembly, which at the time had this so important role. But again, today, the Parliamentary Assembly seems to be weak. It's a club of it is representing this club of democracies. It has 324 national deputies. It should actually cherish the core values and actively work for them. But it was itself subjected to a scandal, Azerbaijan, so-called caviar connection, and so on. It is just kind of getting on track again. But also as a political body, you do not see in the Parliamentary Assembly the strength which existed at the time, which however does not mean that in certain cases they have an important role, and I will mention this in the context of Russian Federation a bit later. Now we come to Committee of Ministers, which obviously has a key role, and which at the time also played this role, but certainly under the influence of the Consultative Assembly and many pressures from different sides, states who got involved, and so on. Today it is rather insinkable that the Committee of Ministers will agree to expel, to make use of its powers under Article 8 of the Council of Europe Statute, whatever the case may be. And this means that this tool is obviously not having a possible effect. I mentioned already the Venice Commission for Democracy through Law, created in 1990. The Venice Commission has done an excellent work. Its opinions are high quality. For those states who ask for their help, they have benefited a lot. But the Venice Commission can also be asked by Parliamentary Assembly, even European Union, OSCE, against the will of the particular state. And then we see that the particular state often ignores its recommendations, like, for example, its opinion on the emergency laws regarding Turkey. In the case of Hungary, the Venice Commission has prepared in the last 7 years more than 15 opinions, but to not much avail. Therefore, it can only perform its task in a proper environment. There needs to be a whole community around it to help it to strengthen its authority against unwilling governments. Now, there are a number of other institutions. Stelios Berakis yesterday has alluded to them, starting from the Advisory Committee on National Minorities, the European Commission on Racism and Tolerance, the European Committee Against Torture. I was a rapporteur for the OSCE last year on the question of human rights violations in the Chechen Republic. The only institution of the Council of Europe which was allowed at that time to go there was actually the CPT, the Committee for the Prevention of Torture, but Russia did not allow that the report would be made public. So this again limits the impact of such institutions. Also, we do have them, and they all can play a certain important role. As I said, the court has a key role, and since 1998, when the merger took place, and we have now so many individual applications, the hope is that through these individual applications, this gives the proper message to the states, but they always need somebody to hear that message. And we see often that some states, they accept the case, but they do not take any structural measures. Remains the European Commission for Human Rights, which is a more activist institution with a general mandate, and indeed the Commissioner has an important role. We just heard about activists, human rights defenders, we would call them today. Yeah? So the Commissioner is the first to meet those activists and to assist them. And he does, or she now, Dunja Mijatović, they do a perfect job. But also they are limited in the impact. So for give an example, in the recent hearing of the Grand Chamber in the Demirtas case, the Commissioner appeared as a third party before the court. But we don't have yet a decision in that case. The Chamber has decided that it was pre-trial intervention was much too long, and we will see how Turkey will react. So the problem is that also the Commissioner can hardly stop backsliding of countries. Remains the Secretary General of the Council of Europe, which is an important institution and since a few years also publishes an annual report on democracy, human rights and the rule of law. I think not anymore, but until, yeah. But when I look at the last reports, 2017, 2018, it was interesting because the report itself announced or alerted to the tendency of populism and the last one to the alarming threats to institutions of human rights protection, which I found is as clear language as you can expect from such a position. Yeah? Certainly, he could go a bit further. He could use the inquiry procedure under Article 52, but in practice, that is not so easy. He would need the backing of the member states. And this obviously is not always forthcoming. This brings me to the role of other actors. We have heard a lot about the role of civil society, media, also academics. And I think that has only grown in importance in the meantime. So the public opinion, which is influenced in this way, we saw it in the Greek case, also makes an important role today. But the problems are different, the challenges are different. In the Greek case, one could focus on one big issue. Now we have so many issues, so it's difficult to mobilize everybody on this particular one. Very shortly, I will say a word on the case study of Russian Federation and Turkey. In that case, we have done a book which came out last year on the European Court of Human Rights and the Russian Federation, and the subtitle is important because it says the Strasbourg effect. There's a question mark we think has to be added. The question was indeed to what extent this socialization had an effect on Russia, but also what was the effect of Russia on the Council of Europe. And you know that we had in the relationship very difficult times due to some cases which Russia did not approve of, with the result that the Duma gave the Constitutional Court new powers to review the conformity of the judgments of the European Court of Human Rights with the Constitution of the Russian Federation. These were the cases Anchukov and Gladkov, and then in particular Yukos, where the Constitutional Court used these powers. Fortunately not since that time, which I consider as good news. At the same time, we have the problem with paying the membership fees because the deputies lost their voting rights, something which has been remedied only this year and which was, let's say, financially very important to the Council of Europe because the amount at stake was quite considerable. But what I want to point to is the compliance rate. So the Russian Federation is not the worst country when it comes to the compliance rates regarding the judgments of the European Court of Human Rights. It was in 2017, 26%. The average of the Council of Europe is 72%. But then we have an outlier. This country, you all know, Azerbaijan. Compliance rate 1.5%. This sounds like a total denial. And you ask yourself, in spite of these caviar connections, how could it be that Azerbaijan has not been sanctioned more strongly? Okay, the Parliamentary Assembly was paralyzed for some time, but there are other possibilities, other bodies, in particular the Committee of Ministers, and would it have not been for an NGO called European Stability Initiative, even that corruption in the Parliamentary Assembly might not have been brought to light. So just one word, because last year I had this function of rapporteur for the OSCE on this human rights situation in Chechnya. Again, we have found that there is a consistent pattern of torture there, in particular for LGBTI people. And this has been found not only in that, by this mechanism, but also by the UN, by the Council of Europe and other means, and so on. What is the consequence of that from the Council of Europe side? We don't see any particular consequence. So it is even possible that in a member state of the Council of Europe you have systematic torture and not much happens. So this is obviously very disturbing and asks for the question what could and what should be done in such cases. Very quickly also as a case study, Turkey, state of emergency recently, 150,000 civil servants purged, 70,000 charged for suspected links to the coup, more than 4,000 judges and prosecutors dismissed, numerous academics, 700 journalists lost their accreditation. There is no country in the world where more journalists are in prison at the moment than in Turkey. Turkey is still a Council of Europe member state. And the sanctions taken against Turkey are quite limited. I have to say that this came, unfortunately, after a period in which Turkey was actually actively trying to improve its performance. When I was there in 2014, they had adopted an action plan on preventing of European Convention of Human Rights violations. And this had been adopted by the government. So there was this will. But then this degraded well before the coup. And with the coup and the state of emergency, it seems it's largely over. Take the case of the Demirtas, which I have already mentioned, and it shows how intransigent the government is. Kerem Altipamak, a well-known academic in Turkey, he says that the record of the dealing with this situation in Turkey will be a symbol for Turkey's struggle for democracy and the state of law. I'm sometimes thinking, what would have Greek people thought today if the Greek case would not have ended as it has ended? Yeah? They would have felt that there was a historic injustice, and they were thinking, what will Turkish people think in the future of the reaction by the Council of Europe, which is very limited. The court, which in the case Sini versus Turkey decided that there is a a tool which is sufficiently good in order to say that the exhaustion of local remedies has not yet or has still to be performed, and stroke out 12,600 cases in one action. This must have been a big disappointment for the victims. And in other cases, the court has found that when there is a state of emergency, the exhaustion of local remedies could not be functioning properly, and I think this is what we also have seen here. Now, just these days, the Kavala case has been decided. Again, the court found that he has to be released immediately. This was a case of abuse of power by Turkey. The EU has come out with a statement day before yesterday. Has he been released? Obviously not yet. But you also ask yourself, where is now the combined, so to say, effort from the Council of Europe, member states to push for the implementation of this judgment. And the member states of the Council of Europe, they are the guardians of the European Convention. They are supposed to act in the general European public interest. Now, when we look at similarities and differences of the Greek case, with situation today, then obviously what is needed is a determined action, as it has happened at the time, but certainly we know that this was a different context, and it is much more difficult to go against authoritarian governments which use populist and sometimes even fascist policies to stay in power, but which are so-called democratically elected, and which keeping with some of their obligations. So there is an incremental change, not a coup from one day to the other. And this incremental change is much more difficult to fight. The question would be, what are the red lines? Maybe if Turkey would accept again the death penalty. But otherwise, there is not much, obviously, from the practice we can see, which would really merit an expulsion decision nowadays. I wanted to deal also with the state of emergency more generally, but I understand that this afternoon we'll have a presentation on it, so I will skip this and I will come to my conclusions. What are the lessons learned? What is the message of the Greek case? Determined member states make use of existing remedies. The system of human rights protection knows strong elements of peer review. In the UN, it is the Universal Periodic Review, for example. In OSCE, we have the Moscow mechanism. And would we accept, or would we like to have cases of self-suspension like in the Greek case? This was a debate in the case of the Russian Federation, which has actually threatened to withdraw from the Council of Europe. And I'm here indeed with those who say it's better to keep it in spite of the problems, because of the hundreds of individual cases which get decided and which give at least some remedy to the people of these countries. The Greek case belongs to a period when interstate applications were relatively frequent. At that time, the individual applications played a very marginal role. Today it is different, but yesterday we have heard that there is a re-emergence also of interstate applications. So the question is, should those be used more actively again by member states, and not only for their own interest, like the recent case Slovenia against Croatia? The impact of the system depends, as I have already said, whether the state cares about its reputation. This, for some states, does not seem to be the case anymore, whether it is the Russian Federation, Azerbaijan, or Turkey. And then certainly there are these arguments like NATO membership, which also come up in our time. Does the size of the country matter? In the case of Russian Federation, it was about the contribution of 32 million euros a year. So this was considerable. So I come to the finding that the toolbox of the Council of Europe has increased considerably, also as a result of enlargement. But are the tools of the Council of Europe strong enough to prevent backsliding, or have they not been used strongly enough? The Council of Europe is sometimes called the democratic conscience of Europe. Today it is under pressure. This is also due to the lack of support from member states. There is a common accountability towards history. What would have been the reputation, as I just said, had the Council of Europe not acted in the Greek case as it did? Any dictatorship, but also every authoritarian government, ends sometime. And then those who were betrayed in their principles will hold the organization in some way accountable. Therefore, the maintenance of a principled position in line with the mandate is key, even if it cannot be enforced at the moment. The Council of Europe and its institutions are constantly put at a test by regressive forces and can only grow in meeting those challenges. They might have lost appeal, in particular for authoritarian states, but they are still needed to provide legitimacy for governments. One aspect we have also seen in the Greek case was the importance of fact-finding. So it's important to insist on the possibility of fact-finding. I have to say that Russia has prohibited the Parliamentary Assembly to do fact-finding in Russia during this dispute. One possibility contemplated is joint responses. In the UN we have several rapporteurs together come up with statements, recommendations and so on. For the Council of Europe, a joint reaction procedure has been proposed, PACE together with the Committee of Ministers, but some are skeptical whether that can work at all. So I think there is a desperate need to preserve also the legitimacy of the Council of Europe, so reacting to major challenges of our time in order to preserve its key values and obligations. The tools do exist, but a more courageous use is needed. The Council of Europe can only preserve its influence and also provide its services if, for the benefit of the citizen, if it does not suspend the member states. So this is why this should be the last option. But on the other side, there have to be red lines where countries know that they cannot overstep them without the final remedy against, which means expulsion should be a possibility. I come to the end. I think what has happened in the Greek case, and which was called idealistic at one moment, was not idealistic at all. It was taking account of the common interest of the European public interest. And this is not idealistic, this is something we all depend on very strongly for the future of our democratic Europe. Maybe today, and this is a difference I see to the Greek case, we lack the personalities which push this from different sides, which are ready to take a risk, which are ready to take responsibility. And we need an institution which takes accountability serious. So at the time, the challenges were obviously deeper than today. Today, they are wider. And that makes it not easier for the Council of Europe, which has just celebrated its 70 years of existence. Thank you very much.
Thank you very much, Professor Benedek. Your report was rather pessimistic. Μιλήσατε για την διολίσθηση των ανθρωπίνων δικαιωμάτων, backsliding of the last few years. And you said also that what happens if a dictatorship falls? Well, that brings me to mind the reaction of the president of the Marangopoulos Foundation, Aliki Marangopoulos, 5 years after the case in Strasbourg, when she came to the third committee of the General Assembly of the United Nations, and she castigated the member states for not becoming interested about the violation of human rights in Greece. She did that in a passion. The result is she was applauded in the end. And this is the first time that an applause was heard in a committee, which is not allowed. Greece was first in such a case. Another case was, when Greece was first, was when Melina Mercouri came inside the United Nations, in Dag Hammarskjöld's auditorium, and attacked the junta. It was also first. This is not allowed, a member state to be attacked inside the United Nations. But those were the days. Now, the question is, where are the determined states? Where is Norway, Sweden, Holland, and Denmark now, for instance, as an example? And Greece. And that is very important what you said, because Greece, after the liberation, let's say, should have been a leader of the fight for protection of human rights. I used to say that to the ambassadors who came to the UN and to the ministers, that you should be in front. And unfortunately, this did not happen. Greece was not known in the United Nations as a state who is sensitive about this matter and takes leadership. And along with the Scandinavian countries, where I must say that Scandinavian countries for a very long time, they were the good countries in the UN. Recently, because of the political change, the Social Democrats are more or less out of government in these countries. The situation is not the same anymore. The question is how you can keep the matter alive. Is it a matter of personalities? You mentioned that. We don't have personalities. And indeed, in the Greek case, we had Andreas Papandreou, we had Melina Mercouri, we had Theodorakis, and in a different way, we had Maria Beckett, and we had Kitty and Natasha inside Greece, and this had an effect. That reminds me also of what happened in South Africa with Mandela. Mandela was a great personality, and that made things known, and people became sensitized about what apartheid was about. I remember in '88 in the huge Wembley Stadium in London, there was a concert that lasted 14 hours for the birthday of Mandela. And there the leader of the Labour Party, Keynote, was there, and the leader of the Liberal Party. And Mandela personified this leadership. And in Latin America, we had names like Allende, we had Ernesto Guevara. So maybe the lack of personalities, either political or otherwise, have made the issue of protecting human rights less effective, maybe. However, after the case in Strasbourg, which was a sort of intervention in the internal affairs of another country by other states, in the UN we managed to approve the responsibility to protect. which means when a country violates in a very strong way, genocide, etc., human rights, the international community has the responsibility to intervene inside another country. That was used only once, and there was a lot of negative reaction to that. Sometimes from colleagues of yours, professors of international law. Sovereignty is harmed. What happens to sovereignty now, we know, in other cases. The question is, why the backsliding? You said several things. I wonder whether the economic relations among countries, which are quite intermediate, globalization, has an effect in touching economic interests of countries, and for this reason they don't take the leadership in criticizing a country that violates human rights. It's not the case in Russia, because it's different, because this is the East-West issue, but for instance in Turkey and in other countries, including those who are the soft cases of backsliding, in Hungary and Poland, for instance. Well, except of Emmanuel Macron, I don't see any other leader of Europe to raise his voice about what's happening.
Timmermans.
Pardon?
Timmermans. Reinders.
I'm talking about presidents and prime ministers. I don't see any other. That's what I've been political leader of Europe. Anyway, you also touched the issue of sanctions. And because apparently the embarrassment of a state doesn't work. There are states which are very hard skinned, they are not embarrassed. Whatever we do. So sanctions, that was discussed yesterday, and probably you should tell us about what sort of sanctions we could have in such a case.